Welcome, and we are here to discuss employee relationship and labor legislation subject. In our previous video, we have discussed the fundamental terms related to employee relationships. We discussed about collective bargaining. We discussed about workers' participation in management. I hope all those concepts are now very clear to you. And now we move on to the uh, next topic, which is related to labor legislation. And we will take a very brief, quick overview of labor legislation, which will help you in understanding how different laws affect the working conditions, and as HR leaders, how you have to take care of these laws. So, this will help us in understanding the laws. For a better understanding of these laws, you need to study the bare acts of these laws. Uh, this discussion is a bare minimum discussion. The most important law affecting industrial relations is Industrial Disputes Act 1947. This is a primary law for investigation and settlement of industrial disputes in India. It has some key definitions, which include what is industry. Industry is any systematic activity carried out by cooperation between employer and employees for production, supply, distribution of goods and services. This is a very important definition, and this is given in section 2J. Uh, there are many important case laws related to this particular uh, word. You can refer to Bangalore Water Supply case company, and wherein the matter was discussed, and the Supreme Court laid down the guidelines regarding whether the hospitals, educational institutions would fall in the definition of industry or not. Then let us look at the next definition, which is workman. It is defined in section 2S. Any person employed in an industry doing manual work, unskilled work, or skilled work, or technical work, or operational work, or clerical work, or supervisory work is a workman as per section 2S. It doesn't include purely managerial work. If somebody is in pure managerial or administrative role, then that person would not be classified as workman. A workman is somebody who is doing a manual work or unskilled work or skilled work or technical work or operational work or clerical work or even supervisory work. That person is classified as workman. It is defined in section 2S. Then industrial dispute. An industrial dispute is defined in section 2K. Any dispute between employer employees or between employers and workmen, or between workmen and workmen, or between workmen and employer, connected with employment or non-employment or terms of employment, is classified as industrial dispute. So industrial dispute is a very important definition here in the law. Means if there are any dispute between employer and employee, or dispute between employees themselves related to terms of condition, related to employment or non-employment, then that is classified as industrial dispute. We have various authorities established under the act, and these authorities are Works Committee, uh, Conciliation Officer, Board of Conciliation, Court of Inquiry, Labor Court, Industrial Tribunal, National Tribunal. Works Committee is established in every factory where 100 or more workers are working. Then they have to establish Works Committee. It looks after the day-to-day working. Conciliation Officer is appointed by government to mediate and promote settlement between workers and management. If there is any dispute, then that is resolved by the Conciliation Officer, who tries to mediate between them. And then we have Court of Inquiry, which inquires into any matter of dispute. Then we have Labor Court. Labor Court adjudicates matters related to second schedule mentioned in the Industrial Disputes Act. These matters are related to like legality of strike, employee discharge, employee dismissal, employee removal, etc. Then we have Industrial Tribunal, which adjudicates matters which are listed in third schedule of Industrial Disputes Act, which are primarily related to wages, allowances, hours of work, etc. Then we have National Tribunal for any resolving any dispute of national importance. If there is any industrial dispute of national importance, then for that national tribunal is constituted. Strikes and lockouts are covered in chapter 5th of Industrial Disputes Act. Strike is defined as cessation of work by a body of persons who are working. Lockout is done by strike is done by workers. Lockout is done by employer. So when an employer closes the factory and stops the factory work, and doesn't give wages to the worker, that is called lockout. So lockout is a temporary closing of a place of employment by the employer. So strike and lockouts are illegal if carried out during the pendency of conciliation or adjudication. So if any court's adjudication or court's judgment is being implemented, during that time you cannot go for strike or lockout. Similarly, if your factory is operating as for essential services, then you cannot straightway go for strike or lockout without having proper approval, because essential services have to be maintained. Similarly, in government department also, you cannot straightway go for strike and lockout. You need to give proper notice, you need to get it approved, right? 6 weeks notice, uh, 6 weeks notice is required for strikes or for lockout. So after giving notice, uh, after 14 days of giving the notice, the workers can go for strike, and the management also can go for lockout. So I hope this is clear. First thing is strike. What is strike? This is cessation of work by workers. Workers say we will not work. That is called strike. Lockout by management when a factory is closed temporarily. That is called lockout. Right? Minimum 14-day notice is required. 14 days to 6 weeks notice is required. And after this notice, they can go for strike or lockout. Strike and lockout can be done in normal factories, but if it is essential services, then the situation is different. If it is a government factory, then situation is slightly different. What is layoff? Layoff means refusal of employer to give employment due to shortage of power or raw material, or due to similar kind of work. And here only 50% of the regular wages are to be paid. What is layoff? When a worker goes to an employer for job, employer says, no, we don't have work today. We have shortage of power, we have shortage of raw material, the factory is closed, and therefore it is this kind of situation are there, and then worker is paid only 50% of the wages and asked not to come. This is called layoff, right? Layoff is purely temporary. Retrenchment is termination by employer for surplus staff. If the employer says we do not require your service, then this is called retrenchment. In case of retrenchment, some compensation is to be paid at the rate of 15 days wages per year of service. Like if a worker has worked for 5 years, then he is paid at the rate of 15 days into 5 years, for 5 years, and he is paid this much of compensation, right? Closure means permanent closing of a business. It requires 60 days notice to the government, and workers are to be paid some compensation, right? So closure is in case of very extreme conditions where the employer is unable to continue working. All these are given in detail in chapter 5th B in the Industrial Disputes Act. Contract Labor Regulation and Abolition Act 1970. This act requires and regulates the working of the contract labor. Contract labor means appointment of worker through a contractor. Here the employees are appointed by the contractor for a specific contract purpose. However, the ultimate responsibility falls on the principal employer, and the contractor is responsible, but ultimate responsibility falls on the principal employer. This act regulates the employment of the contract labor and provides for abolition of some circumstances like this act applies to establishment where contractors employing 20 or more contract laborers. So if any factory is there where employer is hiring a contractor who is employing 20 or more worker, 20 or more contract laborer, then this act, the Contract Labor Regulation and Abolition Act 1970 applies. Registration. Principal employers must register their establishment under the Contract Labor Regulation and Abolition Act, and contractors must obtain license that they can work as contractors. Welfare and health. Contractors are responsible for providing canteen, restroom, first aid, and timely payment of wages. Right? The contractor has to ensure that there is canteen, there is restroom, there is first aid, and there is timely payment of wages. If the contractor fails, the principal employer becomes liable to provide these facilities because the ultimate responsibility is on principal employer. Prohibition. The government can prohibit contract labor in any process if it is perennial. Like if the government thinks that here there is permanent requirement of worker, then why should contract labor be hired? So the government may prohibit employment of contract labor. The government may ask that you should appoint regular worker. Okay, next law. Next law is that we are going to discuss is Trade Union Act. Trade Union Act was enacted in 1926. This act provides for registration and provides legal protection of trade unions. Any 7 or more members can apply for registration of a trade union. They can form a trade union. The act only talks about registration of trade union. It doesn't talk about recognition of the trade union. Registration of the trade union gives some rights, some protection to the representatives of workers. So that way it's a welcome move. Privileges of registered trade union. A registered trade union gets immunity from civil suits. It is protected from civil and criminal matters related to advancement of workers' interest. If they are doing something to promote workers' interest, that is allowed. Like if they are asking workers to go for a strike, then they cannot be, put to court or put to jail for doing a criminal activity. You see, they are given immunity. So these matters are specified. The immunity to the trade unions is related to working condition, related to advancement of workers' interest, right? So immunity from civil suit, immunity from criminal conspiracy, and so is provided to the trade union representative. There are various types of trade unions as per the law. Craft union. Craft union is based on a specific skill. For example, if pilots agree and form a trade union, that is called a craft union of the pilots. If a particular workers of a particular skill gather and form a trade union, that is called craft union. An industrial union. Industrial union include workers from an industry completely. For example, textile workers association, where all workers working in textile companies are part of industrial union called textile workers union. A general union is open to workers across industry. A general union is like INTUC, ITUC, etc., which are open to every worker from any type of industry. Now let us talk about another law, Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices 1971. This is also called MRTU and PULP Act. It is giving recognition to the trade union. The Trade Union Act 1926 did not give recognition. So, but this law is important. It talks about recognition, right? So it's a significant state level law. It is applicable only in Maharashtra. If in any factory the number of workers working in that factory are to be counted, and based on that, if 1/3 of the workers are part of a particular union, then they are to be recognized. The Act also gives definition of unfair labor practice. Unfair labor practice can be on the part of employer, it can also be on the part of employees. If it is on the part of employer, it means the employer is using unfair practices. This may be like the employer is not giving the workers the right to form their union, or if the employer is not giving proper wages, or if the employer is dominating and is interfering in formation of union. This is called unfair labor practice. On the part of unions, if unions are not allowing workers to work, if the unions are forcing the workers to join union, if the unions are sabotaging plant or machinery, this is called unfair labor practice. There are authorities are like labor courts. If there are any complaints, then employer or employees can go to labor court and get the matter resolved. Punishment: there can be imprisonment up to 6 months or fine up to rupees 2000 or both for committing any unfair labor practices. Then we talk about Minimum Wages Act. Minimum Wages Act was enacted in 1948. Now this act is being replaced by Code of Wages 2019, and which is more comprehensive than the Minimum Wages Act. The Minimum Wages Act 1948 required that the central government should give some minimum wages, that is floor wages. State governments could also fix minimum wages higher to the minimum wages fixed by the central government. This act had defined wages. The wages included any remuneration capable of expressed in terms of money. It included basic, DNS allowance, etc. The government fixed minimum wages and revised them at proper intervals not exceeding 5 years. So this was the main purpose of Minimum Wages Act. And working hours were also fixed. The working hours were 9 hours or 48 hours per week. Overtime had to be paid double the normal rate. This overtime provision and these conditions are now part of Code of Wages 2019, because Minimum Wages Act has been replaced by Code of Wages 2019. Let's now talk about important law related to work, and that is called Factories Act. Factories Act was enacted in 1948, and it has many important terms which included factory, a worker, and it talked about safety, welfare, working hours, uh, and these. It's a very big law. We'll discuss about it sometimes in more detail too, because there are so many provisions in it. It's a very comprehensive law, and it has different chapters. Chapter third is about health. Chapter fourth is about safety of the workers. Chapter fifth is about welfare, and chapter six is about working hours. Uh, then we have Maternity Benefit Act 1961. It is there to provide a maternity leave, maternity benefits to the workers. Women must have worked for at least 80 days in the 12 months preceding delivery. They get 26 weeks of paid leave. So these provisions are now enforceable, and uh, this is a very important law for bringing good working condition for women workers. Then another important law is sexual harassment of women at workplace. It is called POSH Act 2013, and it gives definitions related to sexual harassment, which include unwelcome acts like physical contact, or demand for physical favors, or sexually covered remarks, etc. So this is a very important law, and there is internal complaint committee, and there's also local complaints committee at district level. Eh, at if any such matter is there, the women can approach internal complaint committee and get the matter resolved, and within time limit of within a period of 90 days, the inquiry is done and the report is submitted, and it is the duty of the employer to regularly organize awareness and create uh, I mean proper work environment so that women feel protected. So you may go through these laws in detail, and if you feel if there are any questions, we will discuss those questions in detail. The purpose is that you should feel very confident in attempting these questions, and obviously, the Factory Act is a very comprehensive law, and all these laws are very comprehensive, detailed, and we'll discuss about them in more details in our next classes so that you are able to feel comfortable in handling these. And being HR executives, you should be able to handle these laws well, and you should promote greater awareness of these laws among employees and among your colleagues.